amazing and exciting guest, practicing attorney for over a decade, Matthew Becker. He is also the owner and founder of Gym Lawyers. And in his time in litigation as an attorney, he also owned a gym of his own, but now he consults gym owners on how to stay safe and make sure all of their business practices are keeping not just their members safe, but themselves too. So I'll let Matthew take it away.
Wonderful. Well, hey guys, I would say good morning, but I guess it's not morning for you guys. It's good afternoon. So it's only morning for me. So how have you guys been doing? It's been a while since we've chatted, one-on-one like this. How's business? How's Canada? You've got your summit coming up in July. How's that going?
Yeah, it's going great. We're really excited. It's going to be bigger than ever this year. So more news to come on that for all of our viewers and audience out there. It'll be big. Everyone's invited, not just our clients. And Matthew was kind enough to speak at our summit last year, which was amazing. So just another reason we're excited to have him talk with us on our podcast today. But we've been good, busy as ever. I see you have been too.
Yeah. So we're a little bit over 2.5 years, I think, in and now with Gym Lawyers and consulting, and it's blowing up. There's all kinds of gym owners getting in all kinds of different issues. So so basically what we do is provide that legal consulting, and I just try to be clear on that. There's a difference between consulting and representation. So representation is the attorney that you call when you get sued, who is going to show up at court and who is going to negotiate with the other side. We'll do some negotiation, but not a whole lot. That's your attorney representative. We try to prevent gym owners from having to get an attorney representative by doing legal consulting. We provide a lot of education. We provide a lot of consulting with, I talked to the gym owner yesterday who wants to buy 3 different Orange Theory franchises, and how the heck do we do that? And then we do a lot of contract drafting. So, everything from all the way from creating a legal entity to selling your gym on the back end, and every piece of legal paperwork that needs to be done in between.
Wow, that's really interesting. So my first question, this I think might segue into some of the other questions we have, is I know your gym was in functional fitness, and when you started Gym Lawyers, you were mostly consulting for the functional fitness industry. It's a tongue twister.
Freudian slip there.
I'll have to edit that. But I'm just wondering, because you transitioned a bit into the martial arts space now. So are you seeing some of this? Are they the same types of problems that you're seeing in martial arts as you were seeing with functional fitness gym owners?
Probably far worse.
Sure.
I would say.
You said it, Nick, not me. No, it's all good. From a general standpoint, we cover, like you said, functional fitness gyms, CrossFit gyms, personal training studios, gymnastics, cheerleading, dance, mixed martial arts, pickleball, parkour. From a general standpoint, we all have the same basic business needs. Okay. And so, there's an easy crossover when somebody calls up and says, "Hey, I've got a gym," and I go, "Great, what's your corporate entity?" That's going to be a universal question, regardless of what kind of gym owner is reaching out to me. From there, when we start to put together some of, let's say, like a membership agreement or a liability waiver, there's going to be nuances in each individual industry that we really need to be paying attention to. So, I'll commonly use the example of the waiver. The first section of the waiver should be your acknowledgement of danger. And this is where somebody comes in and they read your waiver, and it basically says, you can get hurt if you partake in this activity. Okay. And then we have to get as specific as possible with how you can get hurt. You guys will recall the webinar I did not quite a year ago. I think it was 6-8 months ago, where we talked about that really horrible case here in California. And
Yeah.
there was a big question in that case of, did the individual who ended up getting injured adequately acknowledge that they could be rolled over and break their neck through the waiver? And so, as our job is to make sure that each industry now has waivers that are specific to the injuries that come up in that industry. So mixed martial arts is a different danger than cheerleading, which is a different danger than parkour, which is a different danger than functional fitness. So our job is to come through each one of these industries and figure out, like, what are the big dangers? What are the most common injuries? And making sure that we're then providing legal consulting and legal paperwork and everything else that's very specific to that industry.
So just like let's touch on that situation, because I feel like it
shook everybody.
I feel like it shook everybody, and I feel like the people watching the podcast, they connect so much better to the information with like a real life story they know of, that they've heard about. And I know we're super grateful for you to looking into it and doing that webinar for us, breaking that down. Like, did that school have themselves covered, through the waiver? Like, in your opinion, were they covered? Did they have themselves covered? Like, from your research, like into that case, like, were they prepared for something to happen like that? I don't think anybody is ever, because like I have never seen an injury of that magnitude until that situation. But like, what was your take on what happened there from your professional perspective?
Yeah. And I wish I'd have reviewed my notes on that case specifically prior to hopping on here, because I remember there was a lot of nitty gritties, and in the webinar we talked about sort of the layered system here of, like, they had their corporate entity set up properly, they had the waiver, that was fantastic, they had like their DBA filed properly, and all these things that came into step, so that even though it was like $46 million, I think it was a judgment. I think it ultimately went through. I don't really think it settled. And there was now this $46 million judgment out there. The gym was still able to continue to operate. And I remember there was a very big question within the case about the acknowledgement of danger portion of the waiver. And the plaintiffs were really hammering it, saying, there's no way that this, and Nick, correct me if I'm wrong on the facts, but I believe it was like, the guy who came in was like a white belt, and they put him rolling with like a black belt. And the problem was, the guy rolling, black belt, executed a movement that some opinion was too difficult or too advanced, and that the white belt didn't understand this. And he ended up in a bad position. That's how he got hurt. And the plaintiffs were arguing, nowhere in your waiver did this guy acknowledge that he could be paired with a black belt and rolled over and break his neck. And so, no, we don't have to like go through our waiver and be like, you might get paired with a black belt, like try to cover every situation like that. That's a lot on the gym to do that. Yeah. And that's a lot what you guys do in consulting with the gym owners on that stuff. But, we can make it very clear in the waiver that you're going to get punched, you're going to get hit, you're going to get scraped, you're going to get rolled upon, bodies are going to hit each other, bodies are going to roll on each other, and there's a potential that you could break your neck. And we'll spell that out very specifically in the waiver.
So in the United States, is there like, because like in Canada, I believe there is a law, that if you're negligent, like it doesn't matter what you sign. Like if the business is negligent, like it doesn't matter what you sign. So like in the United States, like is there anything like that? So like, you have the waiver, they sign their indemnification, they sign their acknowledgement of risk, waiving, the ability to sue all agents of, the facility if something were to happen. However, is there a rule in the United States like regarding negligence? And to be clear, I think a lot of people have their own opinion on what happened in this situation. I'm not giving mine regarding it for many reasons. Okay? The internet trolls are vicious out here, so like Is there something like that in the United States about negligence?
This would be a good time to go over gross versus ordinary negligence.
Man, you guys, you just want to we'll flip the script here. Nick just ratted off every important section of a waiver, and then Sam pops in with gross and ordinary negligence. I'll pretend like you guys have been reading my material. So,
yeah, maybe
the bottom line is yes. Yeah.
I'll take
the bottom line is yes. There's different kinds of negligence. So let's put this sort of and Sam uses the buzzwords, ordinary and gross negligence. And so when somebody walks into a mixed martial arts gym, facility, dojo, whatever you guys want to call it, it is an inherently dangerous environment. Okay. And as a gym owner, you just have to accept that. If somebody walks into my CrossFit gym, it's now an inherently dangerous environment. There are just things going on that people can get hurt. Okay. So you cannot prevent all of it from happening. The definition of negligence is duty, breach, causation, and injury. There's a duty as the gym owner for you to protect everybody there. If somebody gets injured, there is a breach. Duty, breach. Okay, somebody got injured. What was the cause of it? Something in your gym caused it. Somebody you're in charge of caused the injury. And so now we have the damage. And do you have to pay out? Right? If I walk into your gym and we're doing some sort of striking, okay, and so I've acknowledged that I can be hit because my waiver has a nice physical contact section in it, and I end up getting punched in the nose, and it breaks my nose. Okay, there was a duty there. There was a breach. There was a cause. Somebody hit me. Okay, do we have damages? Well, some would argue it's in the ordinary course of business of going into a gym that has striking that there's a chance you're going to get popped in the nose. Okay. And so the defense attorney for the gym is going to argue this is ordinary negligence. It's an ordinary course of this business. The gym is covered by the waiver, and hopefully the gym owner is then sort of protected down the line. Okay. And I'm happy to go into those weeds, but ultimately that's what we're trying to do here is protect the gym owner. All right. In the alternative, if somebody walks into my gym, a CrossFit gym, okay, and in the middle of doing muscle ups, the person next to them turns and punches them in the nose and breaks their nose. Well, I had a duty to protect them. There was a breach of that duty because their nose is now broken. And we know what the cause was. And is there damages? Well, that's not ordinary course of business in a CrossFit gym to worry about somebody's going to punch you in the nose. And, perhaps I knew that member who punched is a particularly violent, outgoing member. And when he can't hit a muscle up, he gets a little violent about it. And so I had an additional knowledge that I disregarded. I stuck the new member next to that guy. That guy punched him in the nose. The plaintiff's attorney is going to argue that that's gross negligence because I knew or should have known that there was a problem and I did nothing. I avoided everything. Okay, I took no action to prevent it, even though there was a potential for that to happen. And I knew it. Okay, it was reckless. If it's ordinary negligence, or if it's ordinary negligence, the gym is hopefully covered. We can cover everything. If it's gross negligence, it all goes out to the side. No waiver in the world is going to cover you against gross negligence.
Okay, so here's another scenario. I know I'm like we went over a brief before, but I have these questions of these situations that every gym owner goes through.
That's free flowing.
And myself, and I feel like these are like the most important questions. Like I was going over this just this morning or yesterday. Okay. So martial arts schools sometimes attract, or all the time attract, all types of different people. And, say you have somebody that's come in there, you don't really know too much about them, but somebody in the community has spoken to you and said, hey, this is my experience with this person, at my school. questionable behavior on their own, may be involved in something, okay, that is not, proper, like something illegal. But like, again, and again, school owners asking me this, I go through this, throughout the years, what is, from a legal perspective, what is the right answer? Because it's like you said, right? You're like, hey, you got this crazy guy in your gym, and he goes and he punches the person beside you, which has happened in my gyms before, people getting in fights. And there has been red flags. There has been things that we have seen to get rid of these people. So in knowing this, you're basically saying, you as a gym owner, if there's somebody in your gym that has the potential or I'm not sure the way to articulate the possible potential to hurt others in some way, and you have seen red flags predicting that, the onus is on you to get rid of them, because you're going to be responsible for their behavior inside of your school, whether you had anything to do with it or not. Is that correct? Am I on point here, or am I all over the place?
Yeah, no, you're on point. And from your business perspective, some listeners might sit here and think, oh, well, the less I know, the better. And that's not a good tactic to take when it comes to the law. Okay. In your instance, you said something about, I get a new gym member and you call me as an old gym owner and says, hey, watch this guy. There's a reason he's no longer a member of my gym. Okay. I'm unfortunately now burdened with that knowledge and I have to act accordingly. But that knowledge is power, because if I ignore that and that gym member goes and does something now, that's a surefire way to prove gross negligence, is that I, as the gym owner, knew and I didn't do anything about it. Or I took active steps to not know. Okay. That can all go into, real problems down the road if this sort of thing gets challenged, if somebody ends up suing the gym. And so from a gym owner's perspective, the more you know about your members, the better off it is, because then you can make educated decisions on behalf of your gym and your business that are going to help you move the business forward. And I'm a gym owner. I know that losing one member a month seems to sting far worse than the glory of gaining 5 members in a month. You don't want to have that conversation with a member of I'm sorry, you can't be a member here at the gym. Okay. But if you're going to look at the long-term length and financial wellness of your gym, the cost benefit analysis of getting rid of one member in order to help protect yourself against the risk of a lawsuit and the cost that's going to be associated with that, I can assure you the lifetime valuation of that member is not worth keeping them around. Okay.
Well said.
You have to. It's part of being a business owner. You got to make those hard decisions. I did it once in my gym. Again, it's CrossFit. We had an individual and he had some legal issues and I had to tell him to leave, and it was not an easy thing to do. But as a gym owner, that's your responsibility. Legal issues?
Well, how did you find out about those legal issues?
Yeah, I got a phone call from one of my members who pointed out. So this guy, he had some federal convictions for possession of child pornography, and so he was on the Megan's list. And one of my members called and said, I don't remember exactly how it went, but it was basically you put a video of this guy on your Facebook, and one of our members' friends saw the video on Facebook and they recognized him as being somebody on Craig or Megan's list from their neighborhood. And it was like wildfire. But by the end of the day, everybody in the gym knew that this guy was on the Megan's list and he couldn't be around any kids. So there was nothing. I mean, I had no problems with the guy. I used to be a criminal defense attorney, so I'm all about giving people additional chances. And I struggled pretty hard with having to terminate him. But at the end of the day, I was a business owner and I had to do what was best for my business. And God forbid I ignore it, and he ends up with a situation with a kid, and it wasn't worth it. It's not worth it.
Yeah, 100%. Okay, so top 3 things every martial arts school owner should do from a legal perspective. You're like, you know what? Here's the top 3, guys. If you're not doing these, like you're on, business suicide. Like you need to have these top 3 things done for your martial arts school. What would those be, Matt?
So first one is making sure that your corporate entity is set up properly. And I'll try not to use like big legal jargon here, but every business should be owned by either, down here in the States, mainly an LLC or a corporation. Okay, there are variations. Up there in Canada, it's like all corporations, but down here, it's an LLC or a corporation. And that is known as the legal entity. And you can't just like go on your state's websites down here or go to your province website up there and file the legal entity and walk away and be like, okay, I got my corporation. I'm done. I'm protected personally. My personal assets are protected against anything. There's a ton of formality that goes into it after that. And so that's like one of the main conversations we have with what we call an established gym owner, which is somebody is in business, right? They're not calling to me, would be like, I want to start a gym. They're calling me and saying, I've had my gym for 1, 2, 3 years. What do I need to worry about? That's the first step. I'm going to audit that legal entity. Because if it's not set up properly, it doesn't matter about the other things I talk about. The gym owner is personally still exposed to any negativity that comes down the line through the law. Okay. And again, like, I'm happy to go through the weeds on this stuff, but I'm just trying to keep it like easily digestible because it can get very complicated very quickly. And like, every gym owner is going to call me with a different legal entity and a different setup and a different problem in a different state that has different requirements. So the "it depends" answer will come out of me very quickly.
That's fair, but the main point is that you need to make sure that your corporate entity is set up properly and appropriately for whatever jurisdiction you are in, if you're in province, state, whatever. Right.
And I can tell you 9 times out of 10, if you didn't use an attorney to set it up, you're not set up properly.
Yeah, that makes sense.
So use an attorney to set up your proper corporate entity.
Yeah. For anybody starting out, yeah. Please, don't use LegalZoom. Don't use Rocket Lawyer. They're going to get you like a third of the way there, and they're not going to help you complete the rest of it.
They're also not going to help defend you if stuff goes wrong.
A good portion of our clients are in Canada, and I've been talking to people about this. They do sole proprietor. Do you know what that is, or do they have anything like that in the States?
If we're talking the same terminology, then a sole proprietor is essentially you operating your business as yourself with no corporate entity whatsoever.
Yes, that's correct.
Is that what you're talking about? Okay.
Yeah,
yep. That's a big no. So,
hey, everybody watching the podcast, okay? Hey, legacy clients who I've been bugging you for years to set up your corp. If you needed it, straight call out, public podcast, set up your corp. Get out of the sole proprietor. Sorry, carrying on with Matthew.
Why is that bad?
Why is that bad, Matt? Tell everybody why is this bad.
Yeah. Okay. You start a business. The whole purpose, sure, we want to make people healthier and we want to get people to the next level, and we have this, this profound purpose in starting a business. But at the end of the day, we got to make money too. I'm not whatever. So, I have to make money from what I do. And once I make that money, I want to protect that money. Okay. If you were a plumber, or if you were like a contractor, then yeah, okay, fine. We can have the conversation about sole proprietorship because there's not a lot of financial legal exposure there. If I come in and I improperly install somebody's toilet, it's going to cost me what to go back in and reinstall a toilet. It's not that big of a deal. When we're running a gym, we're talking $46 million judgments, right? We're talking $5,000 slips and falls off the back of a trampoline. Okay. We're talking a $50,000 broken arm. I can't afford that. Okay. Sure, I can make a claim over to my insurance about that, but my insurance is going to take every avenue they can not to cover me. Okay.
100%. And
so
even when they do,
at the end of the day,
the least amount that they can give you. Sorry, continuing.
Right. No. So, at the end of the day, the whole purpose of I guess you could say, like, boiling it down, the whole purpose of me and gym lawyers is to look at gym owners and say, gym owner, you're trying to make a living. Let's protect that living. Okay. Yeah. And the law provides us ways to protect the living that you're making, the money you're making, all of your assets, your house, your car. Okay. And the way to do that is to form a corporate entity. And so if we don't form a corporate entity and we're just operating as a sole proprietorship, all right, I'm just operating as Matt's sweatshop, all right, and somebody comes into my gym and they get hurt and they sue Matt's sweatshop, I am 100% on the hook for anything my insurance either doesn't cover or rejects. Okay, it's coming at me. And it may get at my bank account. It may get at my wife if, depending on the laws of the state, it might get at our house. It could take my cars. Okay. All that stuff. So let's flip it over. And Nick's call out there now motivated somebody to go get a corporate entity. That's great. Because now let's say I've got Matt's Gym LLC or Matt's Gym Incorporated, right, operating Matt's sweatshop. And somebody walks into the gym and they injure themselves and they sue Matt's sweatshop. Well, that lawsuit is going to go back against my corporate entity. And if all of that is set up properly, the insurance comes through, they reject it, or they cover everything they're supposed to cover, and the judgment comes at me for more. Either that money now comes out of the business and I'm completely protected. Okay. My assets, my home, my bank account, my car. That's the point, is it's protected. Everything or the worst case scenario is everything I worked so hard for. Okay. And the worst case scenario is I bankrupt the business. Okay. And then, we go through all the bankruptcy proceedings and everything else. But again, all that hard work I've put into making, that's a new gym owner, $4,000 a month. Woo! All the hard work you put in to get there, we're protecting it. Okay. So no sole proprietorships. You are so exposed. At least get a corporate entity on top of that. It's not a big process. It's not a terribly expensive thing to do.
Yeah.
Okay. So that was number one. Number one, corporate entity set up by a lawyer. What would you say is number two?
Number two, and this, number two is really like have somebody review all of your contracts, specifically your lease, before you sign it. That's just like the biggest legal tip, but I'll adjust that because majority of the people who are listening are probably already established gym owners. So I'll kind of adjust number two simply to say, there are people out there who specialize in accounting, who specialize in tax, and you go to those people. There are people out there who specialize in business consulting, legacy, and you go to those people. There are people out there who specialize in boring legal shit, okay, for lack of better terms. Go to those people. It frustrates me personally, and that's just my own demons, but it frustrates me personally when a gym owner brings a contract to me and says, we need to do X, Y, Z. And I go, great, show me A, B, and C. And it's something that they just drafted themselves. And it's like, I can't do anything with this because, here's the web that you just spun that made this so complicated now to unwind this thing. Because for some reason, you didn't feel like, even though you went to that accountant to pay your taxes, you didn't feel like going to an attorney to draft a contract, or you didn't go to an attorney to review that contract before you signed it, to look at the lease, to help you put information in there or clauses in there that will actually protect you, the gym owner. You didn't call an attorney before you signed the paperwork to buy into the LLC that now has $125,000 IRS debt on it. And so that's sort of like step number, or my advice number 2 is like, I wake up in the morning to look at these things. Please give me an opportunity to look at these things. Don't just like try to do it on your own, because I'm here to protect you as the gym owner. I'm here to protect you and all of the money that you're making. A lot of that goes into the legal paperwork that you're signing.
Okay, so get your lawyer to review your paperwork.
Have a lawyer.
Yeah, have a lawyer. Get your corporate entity set up. What would be number 3 of your 3 most important things for martial arts school owner from a perspective?
Yeah, start papering things inside of your gym. And for a gym owner, this is going to come in 3 primary forms. Okay, one is your liability waiver, and that's the one that probably just about anybody listening or anybody who calls you, that's usually pretty standard. They at least have something in writing that they call a liability waiver that they have members sign when they come in, and that's at least a good start. Okay, from there, ideally that person is going to sign up for some sort of membership. And down here in the States, once they do that, that's going to trigger a whole bunch of other potential legal stuff. But in the gym itself, we need that in writing at its most basic form. You're taking $100, taking $150 off of a person every month on a recurring basis. There are things we need to put in writing that technically give you authorization to do that, so we can better avoid problems down the road. We can avoid that member that says, I've been paying for 6 months and haven't been coming, so give me my money back. We can avoid the chargebacks. We can avoid the cancellation notice issues, right? Because we stuck it all in writing and we set that expectation with the member from day one. Okay. And then
it's a waiver.
Hold on. I gotta, can you guys hear me?
Yep.
Yeah.
You're good.
Okay. I just got a notice that said waiting to trying to reconnect. So just want to make sure we're still good. Okay. And number 3 is staff agreements, which I know, Nick, I think you had mentioned wanting to cover like employment contracts. Get your staff, whether it's an independent contractor or an employee, and happy to talk about those distinctions from a legal perspective. But regardless of the tax designation of the staff, get them on a proper staff agreement in writing.
For sure.
So, because I have lots of negative experience on this, I'm just gonna share. Like, I've had a situation where, because not having the proper contract in place and terminating an employee, or wanting to terminate an employee in lieu of notice, that means, like you just said, you're fired and you didn't have the contract in place. Like, I had to give double the required severance for that person. Like, I was on the hook because I didn't have them sign a proper contract.
And there were no write-ups for dereliction of duty.
Yeah, and Jim Bro guy, like, hey man, don't do that again. Like, hey, show up on time. Hey, answer the email. Hey, I'm warning you, if you don't do your job, we're gonna have to sit down and have a conversation. None of that matters, because you need to give like an official write-up, to demonstrate cause. And it was a very painful, it was a very many $1,000s mistake learning learning opportunity. That's what I say to myself, make myself feel better about it. It was a several $1,000 learning opportunity, and making sure that, like, hey, everybody's got to be on contracts now. Subcontractors need to be on contracts, employees need to be on contracts, and because it actually protects the employees as well, but also protects the business, and it helps everybody be on the same page. Like, gym owners got to stop looking at this stuff that they don't understand, because I used to be that way. Oh, I don't understand. So I feared what I didn't understand, instead of taking the time to get educated and not paying the dummy tax. Like, I had to pay the dummy tax in this situation. Say, hey, you're a dummy, so you got to learn the hard way. And now it's like, all right, everybody's got to be on contracts. That's my vent. That's my vent. Got it out of my system. But guys, like Matt is saying here, and I am seconding what he is saying and telling you that it costs several thousands of dollars. And, we will help you. All of us together will help you guys get set up with all those things for your business as well. I had some more questions as well. So we covered like top 3 things. You were like, get set up with a corporate entity. Number 2, always get your documents reviewed by a lawyer, because that's their job. They're masters. They make the black belt paperwork. Okay. And number 3 is more paperwork. Like, everything needs to be articulated. Paperwork. The waiver, membership agreement, employment contracts, like, those are the top 3 you gave us. And I know this question sounds the same, but I know it's not. What are the top 3 mistakes that you see? And I'll open it up to gym owners too, like not just martial arts school owners, but gym owners in general. What are the top 3 mistakes that you see in the industry right now?
Yep. So one, we'll just kind of sort of echo number 2 from the previous list, which is really stay in your own lane, and know that there are people out there who specialize in the law and drafting contracts. And you need, if you're really going to protect your business, you need contracts, you need documents that are written specifically for your business. Boilerplate waivers, boilerplate membership agreements, trying to write your own operating agreements and things like that. Like, that's one of the biggest mistakes that I see is, a gym owner presents me with something that they may not even remember where they got it from. And they're relying on this to be protecting their business. And it's sadly, it's not. And they're all just sort of one ticking time bomb away from big problems, or like you said, that dummy tax, it's going to be far more expensive than it is to just have a professional do it right from the first time. Okay.
So people basically like hack jobbing, whatever, thinking that they're a lawyer, or thinking this is again a affliction with the martial arts industry that I like teaching my courses. It's like, you're a martial arts instructor. You're not a doctor. You're not a psychiatrist. You're not a dietitian. Don't recommend people's, nutritional wellness. Like, stay in your lane, like you said. Stick to the things that which is martial arts. Let the experts handle the rest of the stuff. What would you say is the number two biggest mistake you see from gym owners?
Yeah, number is either the assumption that we've always done it this way, so why change now? Which sort of dovetails with, we haven't had a problem yet, so why do we need to change?
Very flawed logic.
Yeah, those are, the people who come to us and ultimately get work done. In our closing email, we tell them, you need to come back to us once a year. To have anything and everything we've done for you, anything that has changed over the last year, you need to come back to us once a year so that we can look at things, because the gym owners who do this, and got, a waiver from me last year or a membership agreement from me last year, I could tell you 6 months from now or 6 months later after I produced that for them, we probably provided some sort of an update. And it's impossible for me to remember like who has the update and who doesn't. And that's why we say, once a year, come back around and say, hey, here's my liability waiver. Here are the situations we talked about last year. Nothing's changed. Do I need to update my waiver? And sure, there's probably a provision that we've added that's pretty standard across waivers. And we'll just pump that out to them to add right into the waiver. But the law is fluid and it changes and it molds, and just because it wasn't applicable back then, like when everybody didn't have a phone in their pocket, doesn't mean we don't need to now add CCTV and personal surveillance and copyrights and all those other things to our waivers now, because situations have changed.
For sure.
Okay. And number 3, what do you think? Number three biggest mistake.
Oh man, I had 1 and 2. 1 and 2 really good. I felt like number 3.
I have a suggestion that partnership.
Go for it.
Operators agreements.
I was gonna
don't
ask
partnership.
I was gonna ask partnership questions after you said number 3. That was next in line, but sure.
Let's just blanket. Let's answer that with don't partnership. No.
Easy.
I guess number 3. To be a little bit more serious about. Uh-oh, you guys froze. I'm gonna hold for a second. Okay. Number 3 would be don't be shy of setting expectations with your members. And Nick, you kind of touched on this in the beginning or a couple of minutes ago when we were talking about employment agreements. You said, make sure everybody's on the same page. That's just another way that I say set the expectations. And it's hard to do this as a gym owner because it's hard for me to do this as a gym lawyer because we talk about this stuff on repetition every day. We tell 5 people a day we have a 30-day notice for cancellation, or I'm going to take your payment on the 1st of every month. We're going to prorate your first payment to the 1st of the next month. That stuff just rolls off of our tongue. But we then have to be able to step back and look and say, okay, this person's being exposed. This gym member is now being exposed to all of this for the very first time. What expectations am I assuming are there that I can make with this gym member so that we can avoid problems more down the road? The more expectations we set up now, the more problems we'll avoid down the road. And for those of you who are listening, who are like, well, how do I know what assumptions I'm making? That's why Legacy is here. That's why Gym Lawyers is here. Because we all have so much experience in the industry that we can tell you, these are the assumptions that you're making, and these are how we can change your standard operating procedures to set these expectations more with members so we avoid those problems down the road.
100%.
Yeah, I would definitely say, again, the bro code gym, yeah, bro, it's good vibes, bro. It's good vibes till it's not, it's good vibes till you got a disaster going on in your gym because you ran everything loosey-goosey and, it's all about, sorry, I keep on saying vibes because it's funny because if you see this stuff online, it's all about the vibe, my vibe tribe. It's like, no, man, we need rules. We need rules. We need structure. We need order. Or you don't need, but you're setting yourself up for not only failure, but a disaster and liability and litigation by not having these things in order. And, Sam touched on it, partnership agreements,
expectations.
outlines expectations for sure. Every my friend owns very successful restaurant. He's good paper makes good friends. In other words, saying your paperwork is good, then the friendship's going to be good because everybody knows what's up because of the paperwork. And
I might steal that.
Yeah, I would just say that it's probably arguable that the martial arts industry, even over functional fitness, is more dangerous because we're actually fighting each other. Like, this is combat.
Mhm.
So expectations become even more important because you could really hurt somebody. You can hurt multiple people doing this. And jiu-jitsu and Muay Thai, you're very close contact. So it's very intimate. Like jiu-jitsu, you're rolling around on the floor with people and you're choking them and trying to simulate breaking their arms. So if people don't know, and when you that's true. And when you don't educate members on this is how we behave, this is how we train, this is who to train with, then that's when your problems come up. And then you get people quitting or suing the gym. And it's just, it's super important.
Okay, so would you say the biggest mistake in partnerships in gyms is the lack of proper paperwork and the lack of articulation of roles and responsibilities and things really spelled out as much as it could be to a granular level, and even like as far as to say the exit plan of, God forbid somebody be a psychopath, type of thing?
Yeah, that's a fantastic way of summarizing it. It's think of your partnership as your marriage, and think of all of the things, all of the boxes you have to check off before you actually decide somebody is going to be your spouse. Okay. You should be considering an equally long checklist when you're considering somebody as a partner. And then, just as you have a prenup agreement with your spouse, so that we know what happens when things go south, we need, call it whatever you want, partnership agreement, operating agreement, bylaws, all of these different corporate documents, which go all the way back around to the beginning of our conversation of the proper setting up of a corporate entity. We need to talk about, you're right, Nick, who are we? What are our roles and responsibilities and expectations, and getting everybody on the same page from the beginning. And maybe we sit down every year and we adjust to that. And then ultimately, how do any of us leave this thing? And what does that look like? Because if we can answer all of those questions, especially when money's involved, if we can answer all those questions up front, we can try to eliminate as many contingencies as possible. When crap hits the fan and somebody wants out and they want a lot of money and we don't have guidance from that and a black and white piece of paper from the beginning, that's when we get real problems.
Yeah.
Yeah, because then litigation, right? That's what's you got to hire a lawyer.
That's when you call your representing attorney, right? Instead of your consulting attorney.
Yeah.
Well, we've had this happen with clients of ours that you'll have like an example situation.
I've had it happen with me. I'll just be straight up, say it right on here. I've had it happen with me.
Yeah, but our clients too. So let's say that they go into a partnership, no real paperwork, of course. And one of the guys, and this happens a lot because the person with the skill to teach and open the school does not have the money. So then they'll find a guy with the money. The guy with the money is like, I'm going to put in $200,000, whatnot. But there's no discussion of, is this a loan? Am I paying interest? Do I get a partnership share? None of that's figured out. It's just like, I'm the money guy and you're the guy that runs the school. Okay, cool. Well, we've had this happen where they start to open the school and the money guy's like, I don't want to do this anymore. By the way, I need my $200,000. And then, unfortunately, the primary owner operator is freaking out because he's scared. He doesn't know that he's not necessarily required to pay him that money, but also there's a lot of ambiguity because there's no paperwork. So it becomes a mess.
Yeah.
Yep.
Disaster.
Yeah. The other area we see this come up a lot is like two dudes get together and they have this dream of opening up a, let's say, mixed martial arts gym, and they save up all of their money and they pull it all together and they're like, yeah, man, we're going to make millions at this. Let's do it. And they go and they find a spot and they open up and they're starting to get members. And like 1 year in, they realize that like they're barely paying themselves. And one partner's like, I got to go get like a real job, dude. I got to get out of here. And stops doing anything within the gym. Right? And like the other guy's like, what the heck? Like, I can't run all of this. And then now, like, once we do become profitable, I'm supposed to pay you like 50% because you're technically like a half owner, but you're now at like, whatever you're doing now, you've gone back to your corporate job or whatever. I get that call probably on average once a week. And, I go, great, let's see the operating agreement. And they go, no, we don't have one. And I go, well, I mean, okay, it's going to be really hard to get this guy now to kick off and get out of your LLC because you have no way of forcing him out. So yeah, it is. And that's sort of like one of those, even if like you have a partnership, even if you're listening to this, you're like, man, I got a partnership right now and we don't have anything in paperwork. Cool. Let's take care of it now. Like we still can. Yeah. It's just while everybody's happy, let's get everybody to agree what happens when we're not happy. Because that's the time to do it.
For sure.
Matt, I want to thank you. This was like an amazing and very interesting and lighthearted podcast episode where like if people are, interested in getting in touch with you and learning more about your services and like booking a call with you, how can people get in touch with you?
Yeah. Easiest way is just to go to gymlawyers.com. That's GYMLAWYERS.com. I don't hide. So there's calls to action all over the website. And if you go to the contact page, you can get my cell phone. The goal is, we sort of talked about a little bit earlier and I apologize. I think I dropped the S-bomb and now you're going to have to either bleep it or stick the explicit on here. But, that whole suggestion number 2 of gym owners, like take this to a professional. And if you don't want to take it to the stuffy attorney down the road who walks in and out of his office with a suit on every day and has probably never thrown a punch, never rolled on a mat, never picked up a barbell. Like, I get it. All right. We are stuffy dudes, but at least reach out to me and say like, let's bullcrap for a little bit about gym ownership. And then, ask me your legal question. Let me see if you actually have an issue. It's a 45-minute consultation. It's free. Even if you're Canadian and you're like, well, this American dude can't help me, I can at least talk to you and tell you what the potential issues are that you then need to take to a Canadian attorney and ask them about. Like, I'll give you the verbiage to take to that Canadian attorney and be like, where's my assumption of risk and my liability waiver? Okay.
That's huge.
That's about the most I can do for Canadians, but I'll do that.
Yep. And for those watching on YouTube, the link to Gym Lawyers will be posted as well as in the bio for our podcast. So make it easy for you.
Matt, thank you so much. Great episode. I learned lots. I always learn from hearing you speak, and looking forward to seeing you again soon.
Yeah, thanks so much, Matt.
Yeah, anytime, guys. Thank you.